Welcome to the fifth in our series of European and North American approaches to international law. Today we have, the topic is European and U.S. approaches to universal jurisdiction. And if you don't know what that is, you will soon. And it's a daunting task to try to introduce you to one, let alone both, of our highly esteemed guests today. They're both well known, as you know, as scholars and as lawyers. And I'm going to try to do my best, but I want to say at the outset, before giving you their formal credentials, that it's been a real pleasure to work with them over the past few months around what they're going to do today. So they've been unbelievably generous. I realized Michael and Juan, that we've been in contact since October. They've put a lot of time and thought into readings that they put together for students, as well as into their presentation today. And they've also, since they've been here, been quite generous with their time in meeting with students, and have basically done anything we've asked them to do. So we're very appreciative of that. And as you'll see, this is a bit of a reunion for them. So in some ways, part of their talks will tell you how they met, and they have worked together, so it's been fun to sort of facilitate that reunion in Austin. I'll introduce you first to Michael Tigar and then to Juan Garcés, because they'll speak in that order. Michael will begin speaking for about 20 minutes, and then Juan for about the same amount of time. I'll ask a few questions, and we'll get some discussion going up here, and then invite you to join in with the students in the seminar who are mostly seated over here, asking the first couple of questions. So Michael Tigar is Emeritus Professor of the Practice of Law at Duke University School of Law and at American University Washington College of Law. He's taught at a number of other universities in the United States as well as in France. And most importantly, he taught at the University of Texas School of Law from 1983 to 98. That's most importantly for us anyway, where he held the Joseph D. Jamel Chair in Law. Michael's scholarly work is impressive and wide-ranging, both in form and substance. In addition to numerous articles and 3 plays, he's the author or editor of more than a dozen books, including Trial Stories, which he edited with Angela Davis, Thinking About Terrorism, The Threat to Civil Liberties in Times of National Emergency from 2007, Fighting Injustice from 2003, and The Law and Rise of Capitalism, which has 2 editions, the most recent 2000. He also has had a long and distinguished career as a trial and appellate lawyer, and has argued 7 cases before the U.S. Supreme Court and close to 100 appellate cases. His clients are as wide-ranging as his scholarship, including Angela Davis, Lynn Stewart, Kay Bailey Hutchison, and Terry Nichols. He also successfully represented Isabelle Letellier and the family of Ronnie Moffett in a case that he'll discuss today. My first, actually, I got in touch with Michael in part because of that case, because as a result of a donation of some of the attorney's fees he received in that case to University of Texas, so he donated those funds a long time ago. 1 to 2 UT students a year is able to spend their summers doing human rights work under the name of the Letellier Moffett Scholarship. And we finally dug back down and found out where that came from when Ariel Delinsky met Juan Pablo, the senator of Chile, who is the son of Orlando Letellier. And we told him about the scholarship, and he wanted to know more, and we found out that it came from Michael Tigar. So we're really grateful to you for that, Michael. You will see from his talk, if you don't know him already and know this, he's deeply committed to social justice. And shortly before Justice Brennan's death, he wrote of Tigar's career that, quote, his tireless striving for justice stretches his arms toward perfection. So he's going to give us a perfect talk today on the substance, procedure, and limited utility of universal jurisdiction, or at least he'll stretch that way. Juan Garcés, it's also a pleasure to introduce. He is a lawyer and political scientist with doctorates from the University of Madrid and the Sorbonne. He's taught at a number of universities in France and Spain, as well as in Chile and Colombia. Dr. Garcés has also published a number of books, including, and I'll give you the English titles, Sovereignty and Under the Influence, Strategies American and Spanish Global Strategies. And that's from Siglo XXI in 2008. He also published a book entitled Allende and the Chilean Experience, which was just released, I think, in its 3rd edition recently, and the students in the seminar read the introduction to that, the new introduction to that, and Democracy and Counter-Revolution, which he published in 1975. Before the military coup in 1973, when Allende was in power, Garcés moved to Chile to be a political advisor to Salvador Allende. He left, obviously, in 1973. First, he went to France and finally returned to Spain after the end of the Franco dictatorship. Juan Garcés was the first Spanish attorney to use Spain's universal jurisdiction statute in the 1980s, and he'll talk to you about that. In 1996, he thought to use the statute to bring criminal charges in the Spanish case against General Augusto Pinochet of Chile, and that opened up the floodgates of much litigation around the world, which you'll hear about. He has devoted his law practice to bringing similar claims, including against the Franco regime, under that statute. And if you haven't seen the front page of the New York Times today, you should look at it. If you have, you know that it's very much about what Juan will be talking to us about. Juan has been honored for his work, including in 1999, he received the Right Livelihood Award for Outstanding Vision and Work on behalf of the planet and its people. And he was honored by French President Jacques Chirac in 2000 with the, so I won't butcher it, so with the Order of National Merit in France. He'll be speaking today on the struggle against impunity of international crimes in Spain and for universal jurisdiction. Please join me in welcoming
Well, I'm honored to be invited back here and to see so many people that I know. Judge Higginbotham is here, and Maura and Jim and Bill Whitehurst and Jennifer Warren and Patrick Woolley and Susan Klein and so forth and so on. This is a great law school and a great room. But I am most deeply honored to be on the same program with my friend Juan Garcés. Universal jurisdiction. I'll give a definition in a little bit, but I'm here to say, as I said in the paper that the students read, that I am not an acolyte of universal jurisdiction as some omnipresence brooding in the sky. I think of universal jurisdiction rather like I think of salad forks. Salad forks are very good. We're eating salad. But to eat soup with them, not so good. In short, I think that's legal realism. And I am joined in that view of the law by what Justice Holmes wrote. And he wasn't even justice then. In 1870, he hardly recovered from the serious wounds he received in fighting in the Civil War. In the American Law Review, he said, "It is the merit of the common law that it decides the case first and determines the principle afterwards." Now that's a little stark. I wondered what had been happening to me in the Fifth Circuit, Judge, and I should have read this earlier. Lord Mansfield's, in cases of first impression, Lord Mansfield's often quoted advice to the businessman who was suddenly appointed judge that he should state his conclusions and not give his reasons, as his judgment would probably be right and the reasons certainly wrong. It is not without its application to more educated courts. Now, less cynically, what we are engaged in today in the field of enforcement of human rights is the creation of a series of points where human rights are recognized and enforced. And from that, we hope to command an increasingly large consensus about the necessity to enforce that. And that is an important enterprise, particularly with the American courts having taken the position, as they have of late, that there is no judicial review of such things as drone strikes in other countries and torture. It is, to paraphrase Samuel Butler, as though for the American judiciary, they would be equally horrified to see human rights doubted and to see them enforced. Now, the principle of universal jurisdiction is an extension of things that all law students learn about. Our criminal law in the United States is based on the principle of territoriality. That is to say, the trial shall be held in the state and district in which the crime shall have been committed, the vicinage requirement. But that notion is extended in a number of ways, as you've studied, where the males, for example, are used, or where there's a conspiracy in which the trial may permissibly be held under the Sixth Amendment in any judicial district in which an overt act in furtherance of the conspiracy was committed. In one of the remarkable judicial utterances of Justice Frankfurter in United States versus Johnson, he construed the Federal Denture Act as saying that the trial could be held in any district through which the offending denture passed. Now, this image of a set of false teeth chewing their way through the federal judicial district has rested with me, and I use that example quite often. Now, in addition, territoriality is subject to some amendment when conduct that takes place outside the United States is directed towards the forum. That's United Fruit in the antitrust field, where the anti-competitive conduct takes place in Central America, but the design is to rig the American market. And of course, it's also used in narcotics cases. Other countries of the world use the principle known as passive nationality, and the United States has adopted it for some cases. That is to say, if the victim is a citizen or national of the sovereign that seeks to enforce the law, then they'll take jurisdiction over the person and the event. And finally, there's the principle of active nationality, which is the French use, for example, which is to say that they feel jurisdiction in French criminal courts over conduct by French citizens any place in the world. So the concept, so it's not as though the notion of universal jurisdiction has no roots anyplace. The idea of universal jurisdiction is that there are some crimes that are regarded as so serious, as crimes against the whole of humanity, and however they are defined, such as torture, that it is fair and reasonable to try the defendant anywhere. Now, I'm not going to discuss the theory of that, but the practicality of it you're going to see today. Because the country that allows its officers and agents to commit these terrible crimes turns out to be the least likely place where they're going to be tried and inquired into. And it isn't just that the United States courts are not, and that the Obama administration are not hearing these cases, or that the Obama administration is saying, no, it's a political question, not subject to judicial decision, no judicial review of how this person got killed or tortured or whatever. It's not just our own country. We have found the French, when it came time to confront the crimes against humanity from the Nazi period, their courts blithely took the position that the Vichy France government was not Hitler's cat's paw, that it was a constellation of good intentions, and therefore to have committed the crimes against humanity as its agent could not possibly be the sort of thing you would prosecute. And you'll hear from Juan why it is that Spain's universal jurisdiction doctrine turned out to be so important in the Chile case. Now, I had to put a footnote about this. I did this in the second edition of Law on the Rise of Capitalism. You know, you look back, and all you law students ought to go read Chief Justice Marshall's opinion in The Antelope, which involved a ship full of slaves that were being transported in violation of English law and in violation of the Treaty of Ghent, which had been signed to end the War of 1812. And Marshall had held that the federal courts could not declare that slavery was unlawful, and the transportation of slaves was unlawful. You had to give them back to their so-called owners, right? But he did acknowledge that slavery was contrary to the law of nature, but the judicial duty compelled him to do otherwise. The first instance in which a judge has been required to commit an act, a crime against nature, on his own back. But anyway, we get back now to, and I only have 20 minutes, so I speak quickly. The history of Chile, capsule history. 1970, Henry Kissinger and Richard Helms arranged for the assassination of a Chilean general, René Schneider, in an attempt to destabilize Chilean politics. In 1973, there is the coup. Orlando Letelier, who has been foreign minister and ambassador to the United States, leaves and becomes an outspoken advocate against the Pinochet government, really worldwide. And Pinochet first condemns him, purports to strip him of his citizenship, and then on September the 21st, 1976, agents of the Pinochet government, including an American citizen named Michael Townley, explode a bomb in a car in which Orlando was driving at Sheridan Circle in Washington, D.C., and kill him and his assistant, Ronnie Moffett. Now, my partner Sam Buffon and I sued the Republic of Chile under the Foreign Sovereign Immunities Act. And eventually, we got a judgment against them, which eventually we did enforce, and that's where these fees come from. So this was not universal jurisdiction. This is simply a run-up to what Juan is going to talk about about the Pinochet criminal prosecution. Because one of the things that the Chilean government said was that, while they didn't admit they did the killing, that it was a political question, and you couldn't possibly have judicial review of a decision by a sovereign to send violence into another country to kill somebody. And Judge Joyce Hens Green said, "What?" And I can remember the look of amazement on her face. This is a violation of the most fundamental principles of domestic and international law, and to say that there could not be a judicial remedy for it is unthinkable. Now, contrast that with the decision by the judge in the same judicial district saying that there is no federal subject matter jurisdiction to redress drone strikes, which are exercises of violence across frontiers, to execute enemies of regimes without a judicial trial. But that's not our subject today. Fast forward. One of the consequences of Franco's departure was that Spain adopted the regime of universal jurisdiction. One of the consequences of the ending of the Pinochet era in Chile was that Chile supposedly was bringing itself into compliance with standards of international law. But it simply wasn't happening. Pinochet had rigged the judiciary, he'd set up a phony amnesty, he gave himself ongoing political power. The Chileans weren't going to do anything. And they weren't going to do anything even when confronted with the undisputable evidence that agents of the Chilean government had reached out to murder Orlando Letelier and Ronnie Moffett. That, let alone address the questions of tortures and disappearances. So there I was. I finished the Terry Nichols case. I'm sitting in my office. And in Washington, D.C., I've joined the faculty at Washington College of Law, and I get a call from some British barrister. And he says, "Would you read? Pinochet's been arrested in London." And I said, "Yeah, I read about that." He said, "Well, you know, the United Kingdom now has to represent, we've got to provide lawyers for the Kingdom of Spain, and the Treasury solicitor has briefed us as the barristers, and quite frankly," he said, "this is not exactly our line of country, you know. This is a head of state, and there's a lot," and you'll hear from Juan, some of the kind of political clout this guy had. He said, "Would you mind coming to London and helping us work this out?" So my wife, Jane, is a lawyer, and we picked up a couple of law students on the way at Washington College of Law and went to London and worked on this case. And as you know, then, the House of Lords decided that as to certain of the torture, disappearances, and so on, that took place after Britain had signed on board a treaty, there was liability despite the Head of State Act. And then we went back in front of a magistrate. So and I get to London, and I look around and I say to myself, you know, they had a coup down there in Chile. Now, Pinochet has left power, but the military is still there. Who's my client? Who's my client? Is this something that the movement for change in Chile wants? Because Juan had asked the same question in his way, but we needed to satisfy ourselves. I called Juan Pablo, and he flew to London, and we talked, and he said, "Yes, we want this. This is a device that ought to happen. Yes, there's criticism of Spain, the former colonial master of Chile, proceeding in this way, but we want this to happen." And indeed, the way it worked out, not just in the legal machinations, but the way it worked out, gives us a lesson about the enforcement of human rights norms. Eventually, Pinochet was permitted to go back to Chile. But indeed, Karen is right. Encouraged by the fact that he no longer possessed this immunity, the courts in Chile began to open up and began to hear these claims of what had happened during the Pinochet years. And indeed, and I will close with this, the magistrate before whom the case came after the House of Lords had decided, the Bow Street magistrate, Roland Bartle, Now, the Bow Street Magistrates Court is a new building on one side of the square in Bow Street. On the other side is a tavern, and up above it is the room where the Bow Street magistrate held forth in the late 1700s. And you know who that was, right? No, you don't? Sir John Fielding, Henry Fielding's brother. The Henry Fielding being the author of Tom Jones. And Sir John was blind. And he was the Bow Street magistrate. So there we were. I mean, we were close enough to history, you know, even though we were in this ghastly modern building. And so Mrs. Thatcher gets up and she starts not only making speeches, but she put pressure on Bartle to dump the case. And we thought, you know, Roland Bartle he's a member of the English and Empire League and so forth and so on. You know, and we wondered, you know, what is this? Because, you know, the English colonial experience was that England was it, right? As Christopher Brookmeyer said, England conquered other countries' cultures by ignoring them. You know, you'd always get tea in India at a certain time of day because, well, that was why didn't everybody do that? So we were worried. And yet, as we know, Bartle wrote an opinion in which he spoke about this expanding concept of jurisdiction and looking forward to the day when there will be, in his words, one law for one world. And in a paragraph, a thinly veiled attack on Dame Thatcher for having attempted to interfere with the process. But, and I close with this because Karen wanted, and I'll add what Juan said about, because he clarified that. The great thing was the direct examination of the Scotland Yard detective. Now, the direct examination isn't conducted with question and answer. The detective simply steps into the box, you know, takes the oath, and tells the director. And he says, well, on 3 months ago, I was given a warrant. And I went with the sergeant, and we drove out to this house. And I got out, and I knocked on the door, and I said, I have a warrant here for Augusto Pinochet Ugarte. And they invited me in, and they made me wait 20 minutes. And finally they opened the library door, and I walk in, and I see a man who I recognize as the prisoner. He's wearing a silk jacket, he's got a cane with a silver handle. And I walk up to him and I said, Augusto Pinochet Ugarte, I arrest you for the crimes of conspiracy to torture and to genocide. And sir, I tell you that you need not say anything. However, anything you do choose to say will be taken down and can be used in evidence against you. And should you remain silent now, but later on decide to give an explanation, I will be permitted to comment on your silence. And he looked at me and he said, I don't recognize your jurisdiction. And that was one. And he also exclaimed, this is Garcés. He's a communist. But I thought to myself, busted. The head of state, right? The exercise of this power. Now, there are exercises of this universal jurisdiction to which I would be opposed. And you can ask about that in the question period. This one was logical. It was logical. It was fair. Some of the victims were Spanish. Yes, there was a universal jurisdiction. There's a historic connection that had always existed. And so it could be said that this met whatever fundamental idea you want to have about fairness of prosecutions of this kind in the modern world. And of course, the result of it was that despite the fact that Pinochet was let go on, principles were established that were extremely important in the course of the process. Trials are not always about ultimate results. They're about certain things that happen. If you read Robert Ferguson's book about the Aaron Burr trial, there's some markers there that you might want to take a look at. So there it is. This is the concept of universal jurisdiction. Yet another one of those tools that responsibly and sensibly used can be the basis for an expanding view of human rights, particularly with respect to perpetrators in countries that have deliberately chosen to embark upon systematic human rights violations and at the same time systematically to deny access to judicial redress.
Good afternoon. It's an honor for me to be present today, together with my friend Michael Tigar, invited by the University of Texas, with so much distinguished audience. And I apologize not to speak in my own language. And so, English, you will realize that is not my academic language, and not my forensic language. But nevertheless, I will do my best. After the explanation by Michael Tigar, I can tell you that the case that we opened in Spain in 1996 was inspired by, I can say, two thinkers, one philosopher and a jurist. The philosopher was Immanuel Kant and his concept of a cosmopolitan law. The law of humanity is the subject of law. In fact, something that has been evolving since the end of the 18th century. Kant, in my view, is the philosopher that better condensated the principles of the French Revolution. The concept of humanity is subject of law, and the crimes against humanity that offended all the human space. And the other.
You're having a hard time hearing you in the back. Just
Excuse me?
myself.
Yeah. Okay. And the second personality that influenced our work was a jurist, also German, Hans Kelsen, that in the 30s wrote that the idea of law, in spite of everything, seems still to be stronger than any ideology of power. That was written when Europe was under, a part of Europe was under the influence of Nazi-fascist regimes. And in fact, the rule of law is a political idea that supposes that it is good to be ruled by law as an alternative to any other form of governance or social contract. The rule of law principle can be co-opted and fought, such as human dignity or equality. It is no less vulnerable to social life because it is undermined and co-optable. The fact is that in my particular experience, I realized that in Chile has been committed a crime against humanity in a massive way. And the courts were closed for investigating any disappearance, any case of torture, any murder for political reasons. And then in Spain, in 1997, we were looking at that the Cold War was over, and that in the United States was a government, and that was elected after the end of Cold War. And in particular in Washington, D.C., the Letelier case gave the opportunity to the FBI and other intelligence agencies to investigate the network of crimes committed during the regime of Pinochet. So when we filed the claim in Spain, that was because the courts in Chile were closed. And as Michael said, behind our claim were all the victims of Pinochet that came to the first court that was really to hear them. So it was not an initiative that came from Spain to enter inside the judicial system of Chile, but it were the victims of the crimes against humanity committed in Chile that came to the first court that was open to them. That is very important. Now, the universal jurisdiction is a principle that is very can be very beautiful, but is very difficult to apply. Normally, always, the main evidences are in the territory in which the crimes are committed. The victims are normally always there. So, but for us, it was important to get the evidences of those crimes, and we benefited very much of this inquiry in the Letterer case in Washington, D.C. And we applied the international conventions and treaties between Spain, Europe, and the United States, asking for judicial cooperation between the authorities in the United States and the Spanish authorities for getting in Spain the evidences that were collected in the Letterer case in Washington, D.C. And we asked also for the cooperation from the State Department and the White House for the classifying evidences that were collected by the U.S. authorities during the period of those crimes being committed in Chile. And I should say that our request, legal request of cooperation, was understood in Washington, D.C., and this cooperation between the courts, the Spanish magistrate was authorized to come to Washington to hear some witnesses in the presence of District of Columbia magistrate. And that is very important, because not only we got this evidence, there was the core of the investigation in Spain, but we got the political understanding of the case open in Spain. And that is very important. When you have in face of you power, might, the courts certainly can want, that was the case in Spain, to make justice, to apply the law. In Spain, international law is a law of the land as soon as the treaty is ratified and is published in the official records of the state. So we found in Spain in the 90s a court that was ready to apply the law. But when you have in face of you states that are protecting the impunity of high-level officers, if you don't find international understanding and cooperation, it becomes practically impossible to apply the law. And I will give you just an example of which were the real power and the real might we were facing. This is a speech in the House of Lords in July '99. Pinochet was arrested in October '98, applying the International European Convention on Extradition that was signed and ratified by Spain and the United Kingdom. But after his arrest, an international coalition, two international coalitions were formed in an informal way. One was for the immediate freedom of Pinochet, and another coalition was for accountability for his crimes. And the two international informal coalitions were very active during the 500 days in which Pinochet was under house arrest in London. And one of the most important voices for the immediate freedom of Pinochet was Margaret Thatcher, the former Premier of the United Kingdom, that went to the House of Lords, made a speech. The last statement is 3 points. Henceforth, all former heads of government are potentially at risk. Those still in government will be inhibited from taking the right action in a crisis because they may be later appear before a foreign court to answer for it. That an action in a crisis, the right action in a crisis, this was a case about massive tortures, massive disappearances, and massive murder. For Lady Thatcher, that means taking the right action in a crisis. So that is the real fact. some people in governmental responsibilities want hands-free for taking the right action in a crisis. Then the risk was that they may later appeal before a foreign court to answer for it. And in a final ironic twist, those who do wield absolute power in their countries are highly unlikely now to relinquish it for fear of ending their days in a Spanish prison. This is a Pandora's box which has been opened, and unless Senator Pinochet returns safely to Chile, there will be no hope of closing it. I think that in this brief statement are condensed what are the challenges for universal jurisdiction. But there is here something that is not true, that those who do wield absolute power in their countries are highly unlikely now to relinquish it for fear of ending their days in Spain. In fact, dictator normally doesn't accept to renounce to this absolute power. When this power arrives to an end, it's because other factors force them to relinquish the power. And that was the case also for Pinochet. Pinochet lost the power in 1989 after he lost the first referendum that was possible for the Chilean citizens to vote. And I should say, I was living in Washington in those months, those days, that the Bush administration was already, yes, no, it was still Reagan. In 8 years, it was still Reagan, the presidency of Reagan was very active to avoid and to finally to ensure the failure of Pinochet during the night of the referendum, to not recognize that he lost the referendum. So I can say that in the same way that in '73 the pressure from the intervention from the Kissinger and Nixon administration was absolutely instrumental for the success of the coup d'etat in Chile. In 1989, the United States government was instrumental to ensure the failure of the new coup by Pinochet. That is the real point. But in fact, this understanding in Washington of what we were doing in Spain was absolutely necessary and absolutely useful for having also the understanding in the United Kingdom for executing the warrant of arrest, and also in other governments in Europe, in Germany, in France, in Belgium, in such a way that there was this informal coalition of power that was backing the initiative coming from Europe, from Spain. That means that according to this personal experience that I have in this case, you can conceive the possibility of prosecuting someone that was a former head of the state, even if he was self-appointed, was recognized by the United Kingdom as a former head of the state, only if the law is in your right, plus political backing and political understanding. Otherwise, the law is powerless. And in fact, once again, I quote Hans Kelsen, force without law is tyranny, but law without coercion is powerless. The most important consequence of this case, in my view, has been that because it was this massive backing inside Chile to what we were doing in Spain, that in the fight in the British courts, the government of the United Kingdom in this moment didn't interfere in the courts of England and let the magistrates go ahead with the Spanish request that was certainly without precedent for a former head of state. And we want to know how the debates are in the British courts, where magistrates, judges made their speech, and it's what is the case also in the United States. That is not the case in Spain and France, where there is a ruling signed by the magistrate, but there is only just one speech or only one reasoning. And there were certainly a very, how do you say in English, vivid or lively debate among magistrates on the issue that was in the extradition request. But finally, what is important for us jurists is that the House of Lords accepted that this former head of state could be extradited to be put on trial in Spain. So that was the legal outcome of the case. Certainly, political pressure were present. You should always take into consideration this dimension, this political dimension, in the moment in which the crimes are being committed. Also, where impunity is established, how difficult it is later to prove the impunity. And then, after this decision from the House of Lords and from Bow Street Magistrates Court, the political pressure find a way to avoid the extradition to Spain, or to implement the decision by the courts of freedom. And this schedule was to declare through fake medical exams that Pinochet was suffering dementia, and consequently he was not fit to stand trial. And because this humanitarian reason, then the Home Office applied its discretionary power according to the internal law of England to stop the proceeding of extradition, and decided to send him back to Chile, where during those 500 days the mobilization of the civil society for prosecuting him was so high that immediately that he arrived there, dozens and hundreds of people went to the court filing claims against him, and he ended his days indicted in the Chilean courts. So that is for me the most important and most satisfactory outcome of this case, the opening of the courts of Chile to the victims that came to Madrid. But at the same time, I should add to that this proceeding in Spain was done by with the backing of the democratic segments or sectors of parts of the Spanish society, and against the sectors of Spain that were linked to the Spanish dictatorship of General Franco. There was a clash inside the Spanish courts. The public prosecutor in Spain, we have in this moment a legal system that gives to the victims not only the right to file a civil action, but also a criminal action. And then that was the case. The claim in Spain was a civil plus criminal case by the victims against General Pinochet and some other other people. And the public prosecutor is also present in the case. The public prosecutor is appointed by the government. And it was through the public prosecutor that the clash took place. I was the private prosecutor on behalf of the victims, but in face of me, I had all the time the public prosecutor asking the court to close the case, to put an end to the investigation, and to declare that Spain had no jurisdiction on this case. And I got the backing and understanding of the Spanish court that by unanimity in the French decision, 17 magistrates in the Court of Appeal unanimously declared that they had jurisdiction to know this case, 17 magistrates bench. But the government of Spain was absolutely ready and interested in avoiding a trial of Pinochet in Spain. So there was a pressure coming from the Chilean government to the Spanish government that was requesting the extradition formally because the court asked the extradition, and the British government that was receiving through diplomatic confidential channels the message from the governor of Madrid that we don't want Pinochet in Madrid. When the court was saying send him to Madrid to put him in trial, that was the contradiction, and the solution to this contradiction was declare him unfit to stand trial and to send him back to Spain. That is also a lesson that we could consider, that in cases of this nature, there is a strong contradiction, a fight inside the court in the requesting country. In such a way that in Spain, we have also this extraordinary paradox in that the crimes committed between 1936, the military revolt against the constitutional Republican government, and 1977, the end of the General Franco dictatorship, were committed crimes of war, crimes against humanity in a massive way that are being which prosecution is impossible in the Spanish court, because during the dictatorship that was the case, but after the dictatorship, the transition to democratic form of government has been made in such a way to ensure impunity for those crimes committed during the dictatorship. So here is a paradox. Courts of Spain that were opening their doors to the victims of crimes against humanity committed in Chile or in Argentina or in other places, and nevertheless, for Spaniards, the courts were closed for crimes committed inside the Spanish territory. That was a very strong contradiction. I should say that the sector of the Spanish civil society, of the Spanish political establishment, of the Spanish judiciary, that were understanding and opening up the way in the Spanish court was not the same that was closing the Spanish courts for the Spaniards in the crimes committed in Spain. So this is a very interesting sociological case of conflictual ways of understanding law and applying law, that even the same conventions and the same international law principles. This paradox, unfortunately, has been solved in the last years in a negative way. Margaret Thatcher said that this is a Pandora's box which has been opened and should be closed. In fact, since 1999, 2000, this case of warning in the British courts has been an increasing pressure in the international area for avoiding a new Pinochet case, and also inside Spain. And this interest has been, unfortunately for the United States, also facilitated by the attack to New York in 9/11/2001. All things are related. And in the last years in Spain, there's been a strong pressure coming from other countries to modify the internal law that opened the case, even after the possibility of opening the case in 1998 in Spain, 1996, when I filed the first original request. And in the last weeks, a new law in the Spanish Parliament has amended the internal law on universal jurisdiction, practically expelling from the Spanish law the universal jurisdiction. In this moment, according to this law, we can in Spain apply the passive nationality, the active nationality for crimes interests. Was explained by national interest that was explained by Michael Tigar, but the universal jurisdiction has been cornered and reduced to practically the Geneva Convention. But this is a fact that is still open. And I should say that this amendment by the Spanish government, by the Spanish Parliament, that was approved last month, has been that is publicly known and recognized the outcome of the combined pressure coming from China, because there is a case open in the Spanish court regarding the situation in the Tibet and the crimes against humanity committed in Tibet. And China made very clear that they are the owners of the 20% of the Spanish foreign debt. And they put over the desk that saying, you stop this case, or we will take the economic and financial measure that you can later regret. And the other country that put pressure over the Spanish government, the parliament, was Israel, because the situation in the Palestinian territories and some crimes that have been committed there are also being investigated. And the third country that has put pressure was the United States, because the case of Guantanamo was opened in the Spanish court by some Spaniards that were arrested in Guantanamo, and when they were free, they came to the court saying they have suffered in Guantanamo. So the combination of those three countries and some other countries, probably at least those three countries that is publicly they know, is behind this amendment of the law. Finally, I should say that the universal jurisdiction is part of the struggle for the enforcement of law, and is inside the country for enforcement of the municipal law, or enforcement of the international law, but it's under the influence of this combination of factors that makes that can be helpful, and so much helpful that very powerful influences are concerned to avoid that. My impression is that this fight will never have an end. That is part of the humanity destination. The fight for justice, the fight for the rule of law will never end, and the universal jurisdiction is just one of the ways to fight for this rule of law and democratic justice. Thank you.
Thank you both. I'm thinking that it might be useful to have Michael bring us a little bit up to date on the Kyobo case in the United States, because when we first conceived of this discussion, the alien tort statute is the closest thing in the United States we have to universal jurisdiction, and even though it's not that, people refer to it in that way. And it was actually before we knew that the Spanish, we knew that there was discussion about certainly limiting the statute, but we didn't know that they would do what they did a month ago. So one of the reasons why I said Juan and Michael have been so great about staying in touch is that we've been, particularly in terms of these developments, Juan's been sending them, and it's been a little bit hard because it's like catching up at every moment, including on a case that he just was successful under the Geneva Conventions despite the statute. But anyway, in many parts of the world, the statutes that do look something like universal jurisdiction have started to be limited. And so I think that it would be useful at least to say a little something about the Kyobo decision and maybe what some of the impetus behind that has been.
Well, keep talking for a minute if you would, and I'll look up my notes, because I don't care if I'm wrong, but I'd like to be consistent.
So that was the decision by the Supreme Court last year. You know all of that.
And I'm like, well,
We don't know how to do a control F.
Well, why don't you tell us, if you'll just tell them what they held, then I'm finding my note here. I really am. I'm not fooling with you. You know, I'm a man of a certain age.
But this is, see, much more high tech than the way I do it. I can show you your notes.
Oh, you have it. Oh, okay. Well, there you are.
So essentially, now we have to have minimum contacts or sufficient contacts.
Well,
Not minimum
that
contacts.
is the Mercedes-Benz case that the court just
You want to
decided.
talk about that too.
So let's start with that. The court a couple of weeks ago held that the Ninth Circuit was wrong in finding general jurisdiction to, I'll stand up. It was wrong in finding general jurisdiction to permit victims of Argentinian human rights violations in Argentina. That finding general jurisdiction that a federal district court in California could try that case. And the court's analysis is, well, as we all know, there are two kinds of personal jurisdiction. One is specific personal jurisdiction for claims that arise out of events that took place in the forum, and the other is general jurisdiction that requires a systematic and general contacts and so forth and so on. And you know, this is the triumph of category building over sensible analysis. And it is a part of the genius of judges that want to ignore the reality, because the fountainhead of modern personal jurisdiction law is international shoe. And the fountainhead of international, and the notion of international shoe is that as a matter of due process of law in the modern world, we need to figure out whether it's fundamentally unfair to try a case someplace or not. And the categories, specific jurisdiction and general jurisdiction, were invented as a kind of tools to analyze that. But the court, of course, has forgotten the roots. So the question is it unfair to take the multinational corporation Daimler-Benz and subject them to judicial procedures in California in a civil case, knowing as we do that 95% of civil cases never get tried, but rather, so there will be all this discovery and so forth and so on. And of course, oh no, you couldn't possibly do that. Well, if you can't possibly do that, then why is it that under the multi-district litigation statute, you can gather up all the plaintiffs from all over the country, dump them in front of one federal judge in a place where none of them hardly live, and conduct all the pretrial proceedings, only sending the case back to the originating district in case it has to be tried? Well, that's a well done, as far as I'm concerned. And what it does is it takes the United States courts out of the business, particularly in a case of this kind, of enforcing these universal norms of justice. It limits the number of forms. And so it is an aspect of the problem about which we're talking, because these norms don't mean anything unless they're enforced. You know, this is just, Cora Wiseman is here, this is just Federal Llewellyn now, isn't it? Because she's the world's leading expert. The law is not what it says, but what it does. And there we are. Now, what did I say about you? Supreme Court held that victims of human rights violations committed by a subsidiary of Shell Oil had no right to sue in federal court. That is, the residents were protesting environmental harm, which, by the way, is truly a multinational thing, because this environmental damage, as we know, there's big garbage dumps in the ocean and so forth and so on. So the Shell subsidiary encouraged this environmental harm and provided financial and logistical support. These are crimes against fundamental principles of human rights. The plaintiffs reside in the United States. Now, the court said that even some claims that arise in foreign countries can perhaps be heard, but claims that simply touch, well, these are claims that did not touch the United States with sufficient force. Right? So, once again, here are these international environmental violations by a company that does business in the United States, whose standards for the conducting of that business are largely set in the United States, although they are based in the Netherlands, presumably, because it is Royal Dutch Shell. Do you have my final strophe here? In short, what the court did, and I'm abbreviating this, they accorded the deference due sovereigns to a multinational oil company. That's what the Kill Bill case is about. Multinationals notoriously seek to avoid accountability by outsourcing jobs that can be exported. We all know they do that, to places where labor law is not enforced. I just represented the Service Employees Union, was sued under RICO for its organizing tactics. And because Sodexo's a French corporation, I wrote op-eds for French newspapers and tried to gin up opposition. But anyway, they make deals with complicit governments and so forth and so on. And I finished, where did I find? I said, you know, and it's, to repeat, I said, Shell Oil is not a government. I've been to their headquarters, and they don't have a duty-free shop.
That's all I wanted to say.
That takes care of it. Okay.
So it's a similar situation, it seems to me, in the sense that the United States courts were being used to adjudicate some claims.
We are accused of doing forum shopping, guilty as charged. If you get out of this law school without a keen sense of the necessity of wisely choosing the forum in which you're going to litigate, then you lost something. Yes? What did Horace Greeley say when James Fenimore Cooper said he was going to sue him for libel? He will not sue us in Oswego, for he is known there. And he will not sue us in Albany, for we are known here.
Well, and I think that's one of the stories that you were each telling, in a way, is also about, at the end of today's newspaper, was that now the cases are being tried in Argentina that can't be tried in Spain. In the case of the United States, the Center for Constitutional Rights has been bringing cases to the Spanish court that can't be tried in the United States. So everyone's sort of looking, the activists in one country are looking for a place in another country to bring the very criminal prosecutions that they can't get.
I will not be very pessimistic. Maybe my conclusion was pessimistic. I don't think so. What I am thinking is that when you are trying to put an end to impunity of crimes of this nature, you must conceive, you should establish international coalitions for backing the prosecution of those crimes. What you cannot expect is to do that alone. In my view, what the Spanish government has done, accepting the pressure coming from China or from Israel or from the United States in the case of opening the Spanish court, is a wrong answer. It's a failure for the Spanish diplomacy. What the Spanish should do is to go to other countries that could that are sharing the values that we are implementing, the fight against international crime, and to establish a coordination among the countries against this kind of pressure. And knowing that inside the United States in particular, and also inside Israel, I don't know, inside China, there are important forces and parts of the civil society, part of the Congress, the Congress, that are understanding what we are trying to do in Spain, and then can be established this synergy to avoid impunity. That is the case for the Spanish dictatorship, crimes against humanity that remain unpunished. 3 years ago, the Spaniards that could not open the courts of Spain for investigating, prosecuting those crimes, went to Buenos Aires because Argentina has a jurisdiction has given jurisdiction to the Federal Courts of Argentina to apply the principles of universal jurisdiction. And they filed a claim under those principles against some Spaniards that are, of course, alive for their complicity in the crimes committed until 1977. That was opened by 2 Spaniards. Now, there are hundreds of Spaniards that came to Buenos Aires with their own claims. And the first step since then has been 2 requests of extradition sent by the Federal Judge of Buenos Aires to Spain, asking for 2 tortures to be extradited to Argentina to be put on trial for those specific crimes. And last week, and that is the news today in the front page of the news of the New York Times, last week was the hearing in the National Criminal Court of Spain, the same court where the Pinochet case was born, for this extradition request from Buenos Aires court. And for the first time, the Spaniard that was under torture by this police officer could go to a Spanish court to explain what had happened to him in the 70s. We don't know yet which is the resolution that will come from the hearing. What we know is that the public prosecutor said that Spain should not accept this extradition request because the court can apply the principle aut judicare. That means to reject the request from Buenos Aires but open the case in Spain. That was the request from the public prosecutor, and that is probably what will be done. The prosecutor added that in his view, the statute of limitation applies to this request because in the Spanish legislation, they consider that the amnesty law of 1977 is governing even crimes against humanity. But at least if this recommendation is accepted by the court, the case will be opened in the district where the torture was committed in the Basque country, and according to the municipal law of Spain, the statute of limitation should be decided inside the proceeding and after the inquiry. So at least through this extradition request, the investigation will be open and done in Spain. The outcome of the investigation that remains open. But this is an example of how, through the application of the international jurisdiction principle, the universal jurisdiction principles in Buenos Aires, the first case for crimes of torture committed during the dictatorship in Spain has been opened.
Could I add something to that? Because this principle points up another point here, that the existence of universal jurisdiction in Argentina then forces the Spanish government to recognize this principle aut judicare, aut judicare. That is to say, you either send them there or you adjudicate. The principle of international law is those are your choices as a sovereign state. Now, with respect to whether the statute of limitations or so-called amnesty can be invoked, that's going to be an interesting question. If the only source of the statute of limitation is the so-called amnesty, under international law, that amnesty, that's a phony amnesty, does not operate to end your liability. The principle, that's a limiting principle under the principle of ne bis in idem. And indeed, the French Penal Code, there's an article in Texas International Law Journal I called it a long time ago. The French Penal Code, Crime of Humanity, expressly says that the crime against humanity is not subject to a statute of limitation. Imprescriptible par la nature, by the nature of it. But two other very short observations. This, what Juan is talking about and what his genius is that he understands seeing himself as a lawyer who is considered the interests of this broad group of clients who are in turn struggling for social change. And that's, that's a contrast with the arrogance of some lawyers. I had a character in one of my plays say to Darrow, you lawyers imagine you stand at the center of all the events by which the world is moved. And your right to stand there is only based on someone having suffered or dared or whatever. Now, and there is a limiting principle that's in the papers. I know the student of the International Court of Justice cited the Republic of Congo versus Belgium. And that was a case in which our court held that you could not enforce a warrant against a former minister of the government of the Republic of Congo. And you could read that controversy back and forth as to why that was rejected. But the Congolese judge who sat, because he was better entitled to have that, Judge Bula Bula, I love his opinion and you ought to read it. What he was saying is, what? Belgium is going to give human rights lessons to the Congo? And when you think about it, that's why I started with this idea of how really appropriate it was, and the steps that were taken to give legitimacy, and not just in fact, in law rules, but this perceived legitimacy. That is to say, the victories we win must not only be victories for our clients, but they must command the assent of the world in the sense of having this perceived legitimacy that then makes the basis for progress.
That was the next question I was going to ask at some level, but I'll go ahead and put it a slightly different way, which was, I was going to ask Michael what the soup was, so that the salad fork is not quite perfect for. And really it's a question about social justice and the use of criminal law in this way. So,
well, I meant consomme. I mean, chili, bouillabaisse, it's all right.
But no, because you've both been quite committed to social change, and in much broader ways than just through criminal law, and neither of you saw yourself as a prosecutor before this. And in particular, I'm thinking with Juan, all of the work that you did with Allende and the economic and political project that you were committed to. And so I wonder if you could reflect a little bit about how using criminal law, what your hope, your aspirations for it were in Chile, and whether or not you think they've succeeded.
Well, I can answer to the last part of your question, because certainly I was personal advisor to President Allende, and so I knew very well his thinking, which were his intentions, his acts. In my view, what Chile has suffered is a case of conflict with the principle of the Rooseveltian principles that are embedded in the United Nations Charter. Non-interference, right of self-determination, the freedom for each country to decide democratically the form of government and the economic system. That was briefly the idea of Allende, to apply those principles. What is here, the problem here is that those principles during the Cold War were not put in practice. by the hegemonic powers in their respective areas of influence. When the Cold War ended, there was, in my view, until the attack to New York I mentioned, 2001, a period in which it seems possible that those principles will become a reality in the international relations. Since then, unfortunately, that has not been the case. I mentioned, I will explain why I am so, for me, so important this attack to New York, because it was in 2002 that the US Congress approved the American Servicemen Members Protection Act. In Europe we call that the Hague Invasion Act, according to which the United States was putting pressure over many countries to dissuade them to ratify the Treaty of Rome that established for the first time in history a permanent criminal court, international criminal court. And when the countries resisted this pressure and ratified the Treaty of Rome, then the second pressure coming from Washington was, okay, but you make an exception that you will not apply this treaty when US Army officers or soldiers are involved. Otherwise, that was Russell Secretary who said that we will send troops to The Hague to take out the soldiers of the United States that have been sent to the International Criminal Court. That is the reality. I don't know which is the balance that you do now, as in 2014, on the consequences for the world and for the United States of following these principles in the international politics. It's up to you to make the balance on that. In my view, the balance is negative in terms that we have now a more dangerous world than it was in 2002 and or in 2001. Now the question is where we are going. If we don't apply the principles of international law in a consequent way through international coalitions backing those principles and forcing them, in my view, we will suffer the consequences that could be more dangerous than even the Cold War. I come from Europe. Eastern Europe is now the focus of a strong international tension. And I am afraid of what can be the consequences for the future in Europe and for the world, because once again the big powers are involved in this conflict. And if the international law against the crimes of war, against genocide, against massive crimes of torture, invasions, are not applied in an effective way, then it's not very difficult to understand what can happen. In my view, then it's in the interest, the self-interest of every country, particularly democratic countries, to do the necessary for sending the message that those treaties should be applied. And if for some reason in the country in which the crimes are committed, the courts cannot or will not apply and enforce those norms, then the countries and the court that have this jurisdiction should apply them.
No, I agree. I mean, I agree with that. I think that is very wise. We spent Saturday kind of walking and talking and so on, and I think that's this is a dangerous world, and this is a dangerous game that the United States is playing about regarding its agents throughout the world as exempt from any kind of accountability. Now, for students of law in the United States, this is an extraordinary circumstance, because when you combine it with the kerfuffle over Julian Assange and Edward Snowden, here's what you get. In Marbury versus Madison, Chief Justice Marshall, before he got to saying that you could hold statutes unconstitutional, says that there are some acts for which the president is answerable only is accountable only in his political capacity. And that is the textual origin of the political question doctrine that is now invoked to prevent review of torture, drones, and so forth and so on. But what does that mean? That means that the president is answerable only, but is answerable in his political capacity. How do presidents become answerable in their political capacity? Because we know what they're doing and why they're doing it. So why is the Obama administration in court not only saying that it's not judicially reviewable to torture and so on, but that you can't even have access to the memo that said why we did it? And Senator Feinstein comes onto the Senate floor and says, well, we were going to make the president answerable, or executive branch answerable, in their political capacity. We were going to investigate the CIA. And she makes a speech saying, yeah, but they sabotaged it. They sabotaged oversight. And that, to me, is the central question today about this issue of accountability and why the world is dangerous. And lest you think this is only us, I wrote something about that. Indeed, because one of my favorite quotes is from 1627, Lord Coke in Parliament. God send me never to live under the law of conveniency or discretion, for if the soldier and the justice sit on the same bench, the trumpet will not let the crier speak in Westminster Hall. Well, I kind of liked that. So I sent a draft of my paper that had it in it to my good friend, Lord Justice Sedley, who had written a leading opinion for the Court of Appeal of the United Kingdom, that the Blair government's attempt to have the Queen be absolute sovereign, an issue governed by orders in council. He said, you know, that we're kind of far from that monarchy, and indeed there was a monarch who lost his head over to such an, but they actually had claimed it. The Blair government took that position in the national security case. And so Stephen immediately wrote back and said, oh, that's right, and sent me a draft of his Oxford lecture, which he has since given, with the same quote from Lord Coke. So this is a problem of the Western so-called democracies. And that makes this a very dangerous world, because it not only authorizes such things as torture, but, you know, in the name of something called war, to send lethal violence into other countries, Yemen, Pakistan, so forth and so on, that violates these principles of which, on which Salvador Allende was basing his presidency.
And also Franklin Delano Roosevelt.
Yes, right. So that's what's dangerous about this. Or at least that's one of the things that makes the world a more dangerous place to be than it would be otherwise. And as I say, I think that's what Marshall meant. In Gilchrist versus the Collector of Charleston, Justice Johnson said the same thing in an opinion sitting on circuit. Joseph Story wrote about the need that warlike measures be reviewable by all the councils of government because war could be so ruinous. There's an awful lot of Constitution literature written by people who were alive when the Constitution was framed that talk about the importance of these ideas for us as Americans.
Okay, let's take a couple of questions over here and then we'll open it up.
Oh, the students are on the spot.
Yes.
In your papers, you mentioned that the great powers continue to manipulate principles of international law, and all great powers are permanent members of the UN Security Council.
I noted that, yeah.
And so do you think reform of UN Security Council, such as putting limitation on permanent members' veto power, could be one of the means to proclaim
Did everybody hear that? But in my paper, I noted that the great powers are all members of the UN Security Council, and that the great powers continue to try to shape or limit the forward march of human rights. It was a general theory that the colonial liberation movement that resulted in more than 100 new nation states being added to the General Assembly was responsible for taking the development of international legal norms out of the hands of the great powers, where it had been all the way up to that point. And so the question is, well, where does that leave us? And the answer, so I answer yes to your question, maybe taking away the veto power. The purpose of the Security Council was to make sure that there be collective security and that no nation state be free to use military power except in self-defense. Otherwise, Security Council had to recognize it. Well, of course, now we have NATO and Yugoslavia and 10,000 civilians dead and bombing and so forth and so on. And you can read, I share Diane Johnston's view in Fool's Crusade about that, as well as, and of course we did it under the name of humanitarian law, Jean Bricmont, Humanitarian Imperialism, Imperialism Humanitaire. You can read it in French or in English. There's another book, so we can. So yes. Now, the hopeful sign is that the newly independent states, the nation, and the states that are not members of the Security Council, Spain's adoption of universal jurisdiction is a product of the successful unseating of Franco. Argentine's embrace of universal jurisdiction is the product of a movement for social change in Argentina. And so, perhaps the forward march lies. Although I think the Uniting for Peace resolution in the General Assembly in 1950, as a way of getting around the Soviet veto about going into Korea, was politically motivated. Nonetheless, the General Assembly's actions are now recognized as one of the legitimate sources of customary international law. That being the case, the power in terms of the formation of international law rules of those other agencies is something that we ought to focus on. And it puts responsibility in all of these other nation states that are experiencing their own struggles for justice to play a role. So, that's what we hope is the forward march. And of course, customary international law is a part of the constitutional laws and treaties of the United States. The Supreme Court held that in Paquete Havana, did not regard it as a political question to order the United States Navy to restore to their owners 2 fishing vessels seized as prizes of war in the Spanish-American War. But it's been forgotten.
Yeah, you mentioned that universal jurisdiction is a tool basically, and you would not, or there were uses of this tool that you would be opposed to. Could you explain?
Well,
what kind of?
Well, I think that Juan gave me an example, and maybe he'll talk about it. Juan's case, the Pinochet case, is an example of an appropriate exercise after a thorough investigation based on representation of the pool. And then there was that case in Germany, and you asked them, how long did you take to prepare your case?
Yeah.
So Eurodia was an example of an inappropriate exercise, but John's got another one that I think is even better.
Yes, in fact, we are talking about international humanitarian law, genocide, crimes of war, Geneva Conventions, Convention Against Torture, and the enforcement of this law is a matter essentially for national courts that have, through the domestication of the international law. We have now 2 international courts, the United Nations courts in The Hague, that has no capability in criminal cases. And we had the International Criminal Court only for crimes committed after the Treaty of Rome entered into force, not before. And the United States has not ratified the treaty. China has not ratified it. India neither. Russia neither. So only through the national courts that have domesticated the treaties, it can be implemented. But that needs investigation and building the case. And that is, in Spain, there is now those days discussion on that. If even with the reduction of the jurisdiction in Spain, nevertheless, for applying the principle of judiciary, the investigation can be open in absentia of the alleged criminal. The case is open. I have written a piece on that in Spanish 1 week ago. But that is real. The court cannot go ahead without having the evidences. And the evidences cannot be gathered in a matter of hours. If the big criminal arrives to the airport of Madrid and the press says this man is in this hotel or traveling or walking in downtown Madrid, if someone goes to the court and says this criminal is here, I ask the judge to arrest him and to apply him the convention. The judge will say, well, where are the evidences? If I don't have the evidences, I cannot order his arrest. And that was also, Michael was mentioning what happened to me when several months after the arrest of Pinochet in London. I got a call from Hamburg, someone that said, well, I filed a request to the court of Hamburg to order the arrest of Pinochet. And I want to ask you why you got this order executed in Spain and then in London, and why the court of Hamburg rejected my request to order the arrest of Pinochet, because I was tortured and other people here in Hamburg have been also victims of Pinochet. And my answer was to him, how long have you investigating the facts concerning you in Hamburg? He said, never. So I got the arrest of Pinochet after 2 years and a half of gathering evidences. So the conclusion of that is that the investigation in absentia by the courts that have jurisdiction should be accepted. Otherwise, the people could not get an order of a warrant of arrest by any court.
And this, by the way, is a part of, we're looking here with, the reason I have these ideas about limitation is we are struggling towards a regime for the enforcement of these norms that is not yet perfected and indeed contains many imperfections. And although his statement is a little extreme, it's in 5 American Law Review at page 1 in October 1970. You can read Holmes. That's what he's talking about. What?
1870.
1870. Excuse me, 1870. What do I know? I was born in the wrong century, and we all know that. So there are examples of this imperfection. This was somebody that marches in after 48 hours of research. And then even the International Criminal Tribunal for Yugoslavia, 2-1, the chamber of that court decided that the court can hear anonymous witnesses. And indeed, the Fifth Circuit is just thinking about smiling at me. And the interesting thing is that the majority opinion saying that anonymous witnesses can be used in this criminal case was authored by Gabrielle McDonald, who was a judge of the United States District Court, the first African-American woman judge in the Southern District of Texas, who, in my respectful opinion, ought to have known better. And the dissent was written by a notorious conservative who had been General Counsel of Mobil Oil Australia, then Chief Justice of the Australian Supreme Court, and then Governor General of Australia, and he too has visited this law school, Sir Ninian Stephen. And the only thing I can figure is that since he's from Australia, he knows a kangaroo court when he sees it.
All right, why don't we open up more generally? We still have about 20 minutes for questions, and if I can't, raise your hand high because I can't see everybody in the room.
That's Jennifer Lauren.
It is. So actually, my question relates to precisely, or segues from the question you brought up as it happens. So I'm wondering, right, as one is looking at this emerging system of prosecution for human rights violations, and particularly sort of the procedural side of it, looking at the details of what it means to ensure fair processes in this system. It's interesting, at least from the limited perspective of the United States, to sort of see the flip in advocacy that is often occurring. Sort of demonstrated in part by your career trajectory, right? Sort of being identified as a defense attorney primarily here in the United States, right? But in support of social justice, in support of human rights, in matters of universal jurisdiction and international human rights, you have found yourself, Michael, on the other side of this, in more the role of sort of urging openness to prosecution, right? And I don't know which way this cuts for you, Juan, if there's any sort of shift in that sense, but still, there's a sense in which, you know, in the United States, you're sort of advocating for, you know, human rights norms, right, or principles, norms of justice in the criminal justice system. Well, there are great prosecutors, but you're sort of systematically on the defense side rather than on the prosecution side. When those, and that's the sense of it, when those roles are flipped, right, I wonder what's the sort of forum? Who are the advocates, and how does this get sorted out for pushing for kind of due process norms in these prosecutions, right? You know, the case you were just mentioning, right? If you, Michael, had been, you know, advocating for prosecution in that case, right? Would there come a point where you would have said, "Gosh, I guess I'm going to sort of step back and say nothing about whether we should let this case proceed with anonymous witnesses or not," or I find myself sufficiently kind of conflicted in terms of my view of what would be correct as a matter of sort of due process versus what I think should happen in forwarding the cause of these prosecutions. How does this get sorted out? Because you know, you think about disclosure, you think about
Two sides, obviously. But I think Chief Justice Sullivan has said it. You know, the prosecutor represents as a dual role to prosecute, but also to act as representative of sovereign, whose legitimacy and whose right to govern at all is based on compliance with certain ideas. And I happen to think that, and Jerome Frank, in a case called, I can't remember the citation, United States versus Antonelli Fireworks, and it's his dissent, and that's the one in which he quotes Llewellyn, the law is not what it says but what it does, and my mind is failing, but you can find it with that. And then Jerome Frank's dissent answers that question for folk, okay? And as for me, you heard what I said about the circumstances under which I was to enter into it. I have no doubt that the criminal law is a useful tool in many cases. But I also think that the credibility of it is, the credibility of the criminal sanction system depends on adherence to certain basic ideas, and such as, the right to counsel, the right to effective assistance of counsel, and open proceedings, and transparency, and so forth and so on. Because, the system of legal rules writ large depends upon voluntary compliance, right? That is to say, we can't be following everybody, well, it turns out we can, but we're not supposed to be following everybody around and watching everything they do. And much of the willingness to engage in voluntary compliance depends upon the perception of the system. This was something that we talked about in South Africa with the ANC comrades about this new constitution. What are people going to feel about a legal system now? And what are we going to do to make it worthy of obedience, of voluntary compliance? But that's why this Constitution is the most advanced Constitution in the world, because you had to make a public statement about what we were up to, which, by the way, involved, as a part that I personally feel some role in having recommended, and I'll be publishing these lectures that I gave in Cape Town sometime when we got them transcribed. And that is that since they had 100 judges all with life tenure, and they didn't want to fire the judges that had life tenure, they thought that'd be too much. I said, well, why don't you create a constitutional court? Mandela will name all its members. He will have original and exclusive jurisdiction over constitutional questions, and that's how you can begin enforcing these norms, by creating this new institution. And that was just one of the ways. So I know that's a long and somewhat complicated answer, but that's what we're doing here. we're groping around in the dark. And that's why I think, Holmes never apologized for the fact that he was a Boston Brahmin. Never apologized for the fact that his gift for aphorism often outran his ability at legal analysis. And you see that in his opinions, Yeah, that's what I'm deciding. That's my job. That's what I'm deciding. And yet that very frankness is kind of refreshing. He understood what his role was in the process. We don't quite understand that. I hope that's not too weird.
Ronnie, did you have anything?
Well, you all made the mistake of inviting the general public to this meeting. And I have a question that obviously is a sham for any law student, but what is an efficient way to educate oneself about this largely neglected area of international law and universal jurisdiction in, for example, the New York Times, which I read every day and damn little about it. Why is there such a I'm going to ask you all later if you have texts that I can steal from you on the internet or something, but why is it so obscured from the conscience of the American people, for example? This is not a subject anybody cares about, except a small group or law students.
Mm-hmm. But is your book translated in English?
We're all nationalists.
Well, I write in Spanish. But concerning your question, in English there are in the last 10 years, 15 years, an increasing important bibliography on that. I will mention to you one of the English Italian jurist, Cassese, Antonio Cassese. That has been presiding several ad hoc international tribunals, and that has written a book, the name is Universal Jurisdiction. He's a good theorist of law, and he has the practice of being part of the tribunals. And there are other authors, but I recommend particularly Cassese.
It's a bit of shameless self-promotion. I wrote a book called Thinking About Terrorism, the Threat to Civil Liberties in Times of National Emergency. But one of the things was to assess these various truth and reconciliation, amnesty, the development of international law principles. And in the second edition of Law and the Rise of Capitalism, I tried to capture some of what we were talking about with our question, that is the role of the colonial liberation movements in the newly independent states in the formulation and enforcement of these norms. So those are.
Thank you.
You're also sitting next to someone who can give you some. No, Barbara, you. No, but you can give Ronnie some
All right.
things.
Yeah. I know you shouldn't come needing so much education.
Yes, so everyone who's going to have a question, you think, can you raise your hand so I can get a sense?
Well, we got Bill
Yeah,
Whitehurst
yeah. Okay, great. I've got 3. So yes.
You were just talking about these Truth and Reconciliation Commissions, and that's something I've been thinking about, because let's say you have a civil war in a country and there's, acts of brutality, and then you come up with a system to try to put the country back together that involves broad amnesties or these truth and reconciliation type situations. Well, if you exercise, this international jurisdiction and everything, can't that disrupt that process? And then, if you say that it can, then where do you draw the line? Because Obama says, look, I don't want to get into this issue with these guys that are writing these memos and everything, because that's going to be a divisive thing in this country. I'm just not going to deal with it. So how do you reconcile those?
I am opposed to phony amnesties. Chile, Spain, those weren't real. And if you read the Rome Statute and the treaties, where the principle of ne bis in idem, which is sort of a double jeopardy idea, will not be applied to preclude prosecution if the amnesty was a phony. You know, you can always inquire. So that's one way. But if it's real, then otherwise. So that's the first notion. Second, you know, these dramatic social changes, such as when Mandela walked out of prison, which was something you could predict. You know, Mkoto Msizwe had killed a lot of people, the regime had killed a lot of people. We just didn't know what happened. And so the Truth and Reconciliation Commission was a device, right? That basically said that, you know, it's too soon to write the history of that time. Pierre Nora, the great French historian, has written that, you know, there's this process of memory, the lieu de mémoire, these places of memory. He's a part of the Annals School and makes this distinction between memory and history. We've got a piece coming out of Michigan Law Review in April that'll have some of that. And it's not out yet, but it'll be there. And I try to talk about that. That's why, you know, the arc of memory must not bend towards vengeance. That is a principle. And so the Truth and Reconciliation Commission was conditioned, your amnesty, on disclosure. And the dramatic that you have to see, I think, before you evaluate the drama. My friend Dullah Omar, who also went to this law school, had been Mandela's lawyer, and an assassin had been hired by the government to kill him. And that assassin came before the Truth and Reconciliation Commission. He said, I set up the shot. He was going to come out of his door to get in his car, and then his wife, Rita, stepped into the crosshairs. And he said, I didn't have orders to kill a woman. So I stood down. And he started to cry as he recounted this. And Farida got up and put a scarf around him. And that was on the front page of every paper in South Africa. It was gestures like that that led people to say that we need to go forward here. And this we believe, the people united. We will proceed, as Dullah Omar said, in this law school, we will proceed from legality to legality. And we can have a Truth and Reconciliation Commission because we've got state power. It is not a sign of our weakness, as the Pinochet amnesty was. This is an emblem of our strength. And he said it, right? One of you try to this bill.
Yeah.
So that was a day. I'm sorry.
The question that was put to me a few hours after the arrest of Pinochet, a newspaper man called me and told me, well, Pinochet has been arrested, but are you conscious that what you got can be the origin, the cause for a new military coup in Chile? Because Pinochet arrest in Rwanda will provoke inside Chile from his partisans actions against democracy that will put in danger the transition to democracy in Chile. And my answer was written in the newspaper that I know why the coup d'etat was successful in Chile in '73, and because of that I'm sure that I will not be a coup d'etat now. What I didn't say, I can say that now here. The coup d'etat in '73 was successful in Chile because of the US intervention. But in 1998, it was Carter. No, excuse me, it was President Clinton in Washington, and he was not backing coup d'etat in Chile. So it was absolutely sure for me that there will not be this danger for Chile. But look on that. In fact, what has been going on in Chile since '98, the arrest of Pinochet, is the opposite. It's the development of democratic participation and willingness to put an end to the impunity. And now, we are talking now, 10 years after the arrest, 100 officers of the Chilean army have been put on trial and have been condemned and are in jail. And the Chilean army, and also the case for the Argentinian army, they have been doing a public knowledge of and asking kind of pardon for what they have done for its own, against the population, the respective population. And the courts of justice in Chile now are applying directly international customary criminal law. And not only the convention, but the customary law, something that was unbelievable 10 years ago. So you can realize in this particular case that the enforcement and the help from other countries to implement international humanitarian law has not disruptive effects, but positive effects for the coexistence and the democracy.
So why don't we take the remaining questions, starting with Bill, then Sophia, then Lynn, and if there, I think that'll get us a few. You all can respond and have your closing comments as well. So,
well, my question is similar, but since they're celebrating an anniversary, I wonder if you'd comment on Rwanda and whether you're satisfied that universal jurisdiction doesn't need to be applied in light of the way they have handled this internally, judicially, or whether it should be applied regardless.
Well, there is an international. Go ahead, please.
There are cases open against people charged for crimes of genocide in Rwanda in several countries in Western Europe under the principle of universal jurisdiction. With this is not unconditional international universal jurisdiction. We had in Spain when we arrested Pinochet unconditional universal jurisdiction. That means no link of nationality, of territoriality with Spain, even the crimes were committed abroad. There are several people from Rwanda that are being prosecuted in Germany, in France, and in the Scandinavian countries because they were living in those countries for crimes committed in Rwanda. So the link of territoriality, not of territoriality, but the link of being inside the territory where they are being now put on trial. But they are applying the principle of universal jurisdiction. But as always, politics plays a big role in this kind of facts, of crimes. The last news coming from Europe yesterday, in Rwanda, they are commemorating the anniversary of the 1994 genocide. And they asked the government of France not to come, not to send a representative delegation to the commemorations in Rwanda because of the alleged complicity of French soldiers in 1994 in Rwanda. So you have here several levels of eventual conflict.
Well, I think one of the things that has, it's too big a subject for today, but the fact of the centering of these international special purpose tribunals in The Hague, the fact that Charles Taylor, Charles Taylor, which is the creation of that tribunal is itself complicated. If you're going to enforce human rights norms, the absence of the United States, Russia, China, and India from any accountability is a problem. But if you're going to enforce them with respect to Rwanda or the conduct in Africa or Charles Taylor or Blood Diamonds or whatever, the credibility of the system is seriously at risk if you're trying people in The Hague. Because I've been to The Hague. It's a perfectly nice city, but people are mostly a different color than the defendants. And so if you tried all the offenses allegedly committed by people of color in Northwest Austin, people would start thinking, that's a funny system, isn't it? So if you're going to address these issues, you have to, I think there's got to be some sensitivity. I mean, why couldn't you try Charles Taylor and get kicked out, for example? Again, but that requires the building of these institutions. We're just not there yet. And that's something that good lawyers, and you of all people, Bill Whitehurst is one of the great plaintiffs' lawyers in modern history, and he knows the importance of picking a forum where things can happen. And that's the kind of thing we need to think about.
Yeah, there were some cases brought against Rwandans in Belgium, and where it was criticized along the same lines as what you just suggested with regard to the arrest warrant case also, so, which was sort of the double complication. Okay, why don't you all ask your questions, don't answer until they both ask them, and then we'll. Okay.
All together now.
So, reflecting on your long, illustrious careers, can you give an example of a client or a group you were working for where you feel like you could have changed the strategy to be more successful, or do you feel like the countervailing political pressure was so great that the result was inevitable?
Okay, so my question is pretty different. I was wondering whether, with respect to using universal jurisdiction as a tool for social change, so not social justice, but social change, you thought that it was at all limited by either, one, its largely curative nature, or two, the often significant amounts of space and time that occur between the commission of the crimes and then accountability for those crimes.
Well, first place, with respect to the first question, could I have done it better? Well, I've never lost a case. I've come in second a few times. I suppose that's the thing you're asking about. And the answer is sure, but of course the problem is that issues about wire-client privilege and so forth is going to prevent me from saying that, but, you know, from dealing with it. These, you know, I can think of cases in which I sort of didn't get it. You know, I didn't think enough about what that jury must be thinking, what kinds of concerns they must have. And I didn't get it until it was too late. So yeah, but that's always the risk we take. You know, I tried to talk at lunch today about this. These are journeys we share with people, and we need to spend the time. I talked about Huck Finn. You know, by the end of the journey, Huck's changed. His attitude toward people of color in the institution of slavery, by virtue of the adventure, which is really a march towards freedom, which is a metaphor for what we do, is interesting. And now, the second one is, what about the lapse of time? Well, members, Joel and I have heard the same thing from the doubters. Law and history do not make good bedfellows. Is that right? No, of course it's not. Right? You know, those who do not understand history are condemned to repeat it. And indeed, there are some cases in which the lapse of time makes it impossible for there to be a fair trial. There have been examples of that, and the human rights movement is guilty of that in some instances. But with modern forensic techniques, maybe there are not so many of those as we think. And sometimes there are advantages to the passage of time, because that may help us to understand that what we're doing with the application of these principles is restorative rather than vengeful. And for that, I urge you to read this Michigan piece. You know, memory is not history. There comes a point at which viewing the memory in these lieux de mémoire, these places of memory, through all the possible lenses of refraction, as Nora says, permits us to do something called history. And that, it seems to me, is the challenge. And that's, anyway, you can look that up. I've tried really very hard to write about that because I have such respect for the Annals School and so on.
What I can add to that is that we should take a view, a historical perspective. Crimes against humanity, mass crimes, have been committed all along this history. You open the Bible, for example, and you realize that there are genocides And in fact, the first time that a tribunal is being created for prosecuting those crimes is yesterday, 1945, for thousands of years. No, there were no tribunals putting on trial the responsible for those crimes. Universal jurisdiction is present in legal history since against piracy, against pirates, against pirates since 18th century. But for crimes against humanity, certainly 10 years ago, 12 years ago. So it's before just, even in terms of human history, it's just the movement of eyes, right? So we should look to the Convention of Geneva, 1949. That was after when the memory of the atrocities of World War II were present to everybody. And this is the first time that in a convention is established the obligation to all the signatories to domesticate universal jurisdiction against crimes, serious offenses to the Geneva Convention. So I think that the fact that we are today, and me particularly, explaining the difficulties that we face and the opportunities that are being closed because of international revolutions, that doesn't mean that I think that we should not be optimistic, between brackets, in terms of process. And if some, looking in this perspective, we have done some progress. And what we should take into consideration is which is the alternative to that. In my view, that is the only way to follow. The alternative is more crimes, and with the current level of distractions and modern armament, then what is in danger is the survival of the human rights.
Thank you on behalf of the Rapoport Center to all of you all for coming. And